All right, good afternoon, and welcome to the 7th webinar in Conn Maciel Carey's 2017 MSHA webinar series. Today we're going to be discussing working effectively with counsel during MSHA investigations and contests. Now this is obviously a topic that may or may not come up for anyone depending on your stance in litigation, the types of issuances you get, or the types of enforcement that you might come across in terms of special investigations or anything of that nature. But nonetheless, if working with counsel is something that you do or maybe need to do in the future, hopefully this will give you a bit of a roadmap about when that is appropriate and some of the steps to take to help ease that transition. If you haven't been on before, my name is Nick Scala. I'll be the voice talking to you this afternoon. I am the co-chair of the MSHA practice group at Conn Maciel Carey. Here I represent mine operators and contractors around the country regarding MSHA contests, special investigations, manage investigations during accident and fatalities, as well as representing company management during agent investigations and discrimination investigations. We take in litigation all the way through the Federal Mine Safety and Health Review Commission, as well as settled with CLRs or in informal conferences. So really we've had experience doing this head to toe. I'm also a certified mine safety professional, so I have a bit of a background in the industry prior to getting into the legal side of things. So with that, we can see that today we have an agenda, and it's going to be pretty cut and dry. So we've already talked about it, but first we're going to look at when is it appropriate or when is it a good idea to contact legal counsel when dealing with MSHA. We're going to talk about evaluating different types of situations where counsel might be necessary and maybe at what point during that phase or that process counsel should be called. So is it going to be immediately at the beginning of the process, or is it less urgent that that is the case and you can look at someone coming in later on? Lastly, we're going to look at some basic information that we wanted recommend you provide to counsel at the get-go when we really get involved, so that we can get up to speed quickly and there isn't any confusion regarding what is happening or what is desired outcome for the litigation. And that will help us work more efficiently together and get into the meat of the citations or the meat of the issues at hand, as opposed to wasting time going through some of the periphery. So the million-dollar question, I guess, is when should we engage with counsel? And that question really depends upon what situation you find yourself in with MSHA. The timing of retention is largely going to be based on what you're facing. And that can be whether you're doing just enforcement contest or unwarrantable failure contest, having to deal with investigations on site, whether that is discrimination, liability of agents of management, or, as I've mentioned before, fatality and injury investigations. Obviously, each one is going to have its liabilities and the risks of moving forward and bringing counsel at a later time. So it really depends upon which one of these you're looking at. I think that the good rule of thumb would be that you should get counsel involved as soon as practical if that is your intent. And so that means if you are even doing just minor enforcement contest, if you do have counsel that you're engaged with, or you are seeking to contest the citations, or even just want to evaluate them for the validity or the prospects of contest, getting someone involved early on is always a good time to do that. We could maybe steer you into a direction of avoiding a citation altogether, or getting through it in informal contest, or means of that before we have to get into formal litigation. So those are some different areas where you're going to want to look, and the retention or the time frame to engage with counsel might be very different. First off, we want to look at some of the times where we want to get in contact with counsel immediately. And that is, the big one is first and foremost accident or fatality investigations. And this probably makes the most sense because the risks are the highest here. You know, if I am representing a company, and I've done it both when I've been called on site immediately and have met the inspector out there or been there before the inspector, and I've also dealt with these kinds of investigations and enforcement actions when I was brought in a year later and penalties were finally assessed. And I can tell you from that experience that it is most definitely advantageous from all perspectives of the employer that you get counsel involved as early as possible. You know, that allows us to be on site with the investigator from MSHA and manage that investigation, whether by working with your personnel and working with the investigator, by possibly heading off an avenue that the investigator starts to go down but may not be relevant, by helping them go through the process of identifying what is needed while also protecting the company's interests and not going beyond what is required in doing so. You know, we're also going to be able to help you evaluate the the possibilities of further legal action, whether that is MSHA legal action such as the likelihood of agent liability cases, or if there's going to be concerns regarding third-party liability suits, how that is going to work out. And maybe one of the most important is that when we come on site at the beginning of an accident investigation, we're typically going to be permitted to participate in the witness interviews with the investigator and even represent company management at that time if needed. And that really gives us a big leg up because we know what we're facing in terms of admissions against interest or, you know, possible employee statements that may be adversely affecting our position or could adversely affect what type of enforcement action we get. And, you know, then we don't have to play the game of catch-up later on when, you know, MSHA's done all these interviews on their own and we request their file and every conversation has been redacted due to an informant's privilege, meaning that they are redacting whatever an hourly minor said as an informant to the government. And they can do this, and they frequently do, so that there is not the possibility or repercussions of discrimination against those people if they maybe said something against the interest of the company. But nonetheless, we would like to know that so that we can either get to the bottom of it or figure out how to defend it early on. And so those witness interviews with MSHA at the day of or the day following or the week following an accident or a fatality, those are very, very important because they give us an idea of exactly what MSHA has. Now, it's always possible that the investigator could contact the minors outside of the times when we are present, and hopefully we've educated our minors on the prospects or their rights when dealing with MSHA, and that's another thing that we do first thing when we get brought into an agent or an accident or fatality investigation is ensure that all of our minors, both management and hourly, or rank and file, are aware of their rights, and that is, you know, they do not have to participate in interviews with MSHA, and they can if they want to, but it's not required. So we want to make sure that is well known. We also want to be sure that we are available to sit in on those if the employees will let us. And we want to be able there to, you know, look after the interests of the company and make sure that we can try and head off anything from getting more severe than it needs to be. Also at those times we can really look at, you know, if we are brought in immediately, and obviously with MSHA's reporting requirement at 15 minutes, it must be very immediately, but we can look at, you know, what are the reporting requirements? You know, obviously we want to avoid making that 15-minute call unless the injury on site or the accident on site most definitely fits into those categories. And, you know, that is, was there a death on site? Or was there an injury with reasonably likely or reasonable potential to cause death? Was there an entrapment? There's a whole list of them that we should be familiar with in the definitions of Part 50 to determine when exactly we have to call. Because, you know, just as bad as, you know, having to go through an injury or an accident investigation, as stressful as that can be, regardless of, you know, what has happened. It's even worse when it was a situation where we didn't have to make that 15-minute call, but we weren't educated enough, or we weren't aware of what was required by MSHA, so we made a call that was unnecessary, that we could have just filed a 7001 form. And really that's even the situation where we want to get that education beforehand, so that we know when it is reportable and we know what exactly has to be reportable. So that is an important one when we're looking at this, because that 15-minute call obviously is a trigger to for MSHA to get someone out there. So if you make that 15-minute call to MSHA, I would recommend that, obviously you make that call within 15 minutes of becoming aware of whatever accident occurred. And then, my recommendation would obviously be to call counsel either before or soon thereafter, so that we can be out on site when MSHA is there. In addition to accidents and injury investigations, when are times that we want to be contacted immediately, or we should be contacted immediately? Well, we got to look at that in terms of the contest matters, because that's typically the other time that we are engaged with a company outside of special investigations. And the contest matters, obviously, that is a big realm of interaction with MSHA. And it can obviously be for, we'll call it low stakes. If you have 104A, that's a non-SNS and low negligence, and you're probably going to be at the statutory minimum and penalties. And, maybe then it's not urgent to get MSHA involved until you maybe hit a wall in your negotiations with the agency. And you really think that this is a vacate-worthy argument that you have that the citation is invalid. Well, obviously in that circumstances, it's not urgent to get them involved immediately if you want to take it forward on your own for a while, or if your practice is to contest on your own. As I said before, obviously as soon as practicable or as soon as possible is always favorable from our perspective, but, those citations are something that you can look at as bringing counsel in later on. In terms of that, we also want to look at, though, times when it might be important to immediately bring in counsel, even though you're just contesting something. And that is going to be, looking at withdrawal orders or abatements. How is MSHA handling this? What are they requiring you to do? How widespread is a withdrawal order, or how feasible is the abatement? And those are areas where you need to act a bit more quickly, and you need to have a better idea of the groundwork that you're dealing with. So, in addition to that, you want to look at, what are your arguments? You could be looking at a contest that maybe you have a very strong argument, but you're just not aware of it, and it might be something that we have seen before. But in terms of immediate actions where we would want to be involved or would recommend you getting someone involved is an unreasonable abatement. An unreasonable abatement or a non-feasible abatement can be, the timeline you're given, the scope of the abatement, the money invested in it, or whether it actually improves safety. Any abatement deadline, any modification, any extension, any abatement requirement is contestable. And depending upon that, we have the ability to either contest later on, after we've already done the abatement, and maybe we think that this was invalid, and we put all this time, this energy, this money into it, when we could have done it immediately, and we could have exercised our challenges or our right to challenge that abatement at the time that it was given to us by an inspector. So when we're looking at abatement of a citation, it might not always just be reapplying a guard or reattaching a guard to a tail pulley. It might not always just be cleaning up a housekeeping. What if they want us to construct a barrier around something that would adversely affect business and not actually improve safety and health? Or what if they want us to scale an entire high wall in an area that isn't active? Those are situations where we want to push back, and where if we need to, we can push back pretty hard in terms of even looking at, what do we want to do in terms of dealing with the inspector, and if we get nowhere, dealing with the field office in the district. And if we still get nowhere, pushing back and going through expedited proceedings with the commission. And that is a relief that is available for operators that, we seldom use because it is a very, strong tactic that operators have, in that we're going to be looking to taking something to trial within a month of making that request. Even as short as 5 days if the situation is extreme enough. And so when we make that request, we want to be prepared that we have gone through and evaluated whether or not we can work this out with MSHA, because that is going to be the easier way to get through it. But, we have to be prepared to contest that and to challenge it. This is going to be especially important with long-term or very costly abatements. We also want to make sure that if we are abating anything, that the actions we're taking will actually close out a citation. We don't want to get in a situation with MSHA where they can just keep kicking the ball or the can a little bit out in front of us, that we've done an abatement, and then they come back and like, oh, well, that's not quite good enough, let's do it again. This is something that we want to avoid and we need to avoid, because the longer a citation hangs out there, the worse it is for us and the worse the possible repercussions are for us, including, are we going to be looking at failure to abate citations or orders under 104B. So we want to keep that in mind when we're discussing this. We want to make sure that the abatements are reasonable, not only from the prospect of cost, but can we actually get it done in the time frame? MSHA frequently issues time frames for abatement without ever actually talking to the operator or talking with the operator. So we want to see that and look at the citation when they give it to us and what your abatement period is, because for all you know, it might be 8 o'clock the next morning for you to do 1.5 miles of berming, and they issued it to you at 5 o'clock that evening. So we want to look at that so that we don't set ourselves up for failure. Another time where we might want to immediately get involved with counsel is if we're having withdrawal orders. And, there really are multiple types of withdrawal orders, whether it's a 107A or a 104G or a 104D. And we're going to look at 104Gs and Ds today, because, those are really their chief enforcement tools for withdrawing minors from an area. And, when we're looking at a 104G, it is withdrawing for training violations or lack of training. So, obviously this is a situation where not only are we going to be looking at a penalty, but also we have lost a group of our workforce, either for all work, or if it's a task training G, for a series or a specific task that might be critical to our operation until that training is completed. So again, we want to make sure whatever we do in these situations is going to be adequate. And that's something where I frequently get involved with clients and review what is going to be needed to abate this. How broad does our abatement efforts have to be? What does the training have to cover? And if the citation or the order is vague or is overly broad and we need to get it more pointed, that's something that we need to evaluate at that time before we take steps on abatement. Because, again, just like with unreasonable abatements or with abatement in general, if we are taking action without having clarity, we are, setting ourselves up to failure or for future enforcement with the agency. So, this is one where we really want to make sure that we have a clear understanding of what training is going to be required and how can we complete that training. Additionally, we're seeing pretty frequently that MSHA, especially with training orders and task training orders, are using these as a way almost to hijack your operation or your task training until they get exactly what they want in it. And it may be much more, than is reasonable to include in a task training. And so you really need to consider that, because you're going to have to present your materials to MSHA most likely before you can abate this or complete this. So we're looking at a period that, we have to create a new program or complete some new training and then get approval from MSHA for that training before we can get our workforce back. And that's obviously problematic. So, we want to look at it, and we want to make sure that we take the time to evaluate it, and if we need to take more aggressive action, that's a good time for counsel to get involved, whether it's with the district still or with it moving forward into, more formal litigation stances. Additionally, 104D orders are, probably the most commonly seen withdrawal order, and it's important to know that these are withdrawal orders because working in the face of one is going to result in even more egregious penalties and enforcement. But 104D orders, clear equipment or clear tasks or entire areas from operation. And just like we were talking about before, we want to ensure that MSHA isn't getting overly aggressive in their application or in overreaching in what they're making the area affected. We want to tailor these, and that has to be done through pushback. Now, when we're dealing with 104Ds, though, or even some high negligence 104Gs, we're looking at the area where agent liability can come into play. So it's important to know that, because one thing that counsel doesn't have to face that operations people would is that we are not going to face agent liability. So we have the ability to speak with MSHA without concern that our statements are going to be written down and used against us in a personal action for the purposes of Section 110. We have the ability to go out and just say, look, this is what we're thinking, this is overly broad, these areas aren't working, whereas sometimes the operators are at a stance, especially when a 104D is put out there, that the enforcement action or the investigation or the inspection has devolved into a pretty contentious endeavor. And, that is never a good thing, especially if you're the only person on site or maybe the only management person on site dealing with MSHA. Because if there's an unwarrantable failure on 104D, they've already determined that there was aggravated conduct on the part of some member of management. And they are going to be continuing to take notes on that. So getting an attorney involved, getting counsel involved at this point in time, we can really try and, again, curb the damage that could be done with further conversation with MSHA, especially if it's become a contentious situation. So many 104Ds become additional citations when in a heat of the moment type situation, you make an admission, not even intending to do so, or maybe you don't think it is an admission, you're just stating that, oh, well, we always have done it this way, and it's never been a problem before. Well, you've just admitted to continuing or having a culture of doing something in a way that MSHA finds is a violation of their standards. So those are concerns with dealing with the withdrawal orders, is they can kind of pile on top of themselves, as well as MSHA can get very broad with what they're writing. So we want to be able to, communicate to counsel what our concerns are and why that is a concern. Maybe the area that they're taking out of service shuts down everything that we can do. Maybe it's a loadout and or it's where our trucks cover up their tarp, and by taking that out of service, we can't have any trucks tarping, and then they can't get on the road. Obviously that's a situation where we would need to figure out, is there a new area where they can go tarp, or is this a prohibition of any tarping? Or maybe it's at our feeder, and by doing so they shut down everything. We need to look at those, and we need to be able to push back quickly with MSHA. And I mean that in that before the inspection is over, we want to be able to push back, or the next day. So if we have a situation, or we've decided to engage counsel, we want to have created a foundation for that contest, for that interaction. And I mean this by, and this is really just kind of MSHA Inspections 101, but we want to look at what are we doing to protect ourselves, and what information are attorneys or counsel going to look at when we get a case in front of us? What information is going to be helpful to us? And this is going to help set you up for that. You know, first and foremost, we should all be exercising our walk-around right and accompanying inspector. You know, we should most certainly never let inspectors just walk around unaccompanied on our site. You know, and don't let any inspector tell you that they have the right to do so. You can accompany them at all times. Now, some inspectors push back on the number of people that can accompany them, on the size of the inspection party, or how long they'll wait for that person to get there. But they cannot deny you your right to accompany them while on site. And we want to exercise that right so that we have an idea of what they saw, what they encountered, what they did, as well as just making sure that they don't do anything unsafe, since they don't know that site as well as us. You know, like I said, that some inspectors push back on how long they'll wait. We want to have a system in place so that we can contact the individuals who need to accompany MSHA inspector as soon as they come on site. Or, you know, even to go up the chain in case it is a special investigation and things are going to get more severe. We want to look at, you know, who is going to be contacted, who needs to be contacted, and how are they going to be contacted. You know, I joke, but we want to say almost like a call tree. You know, we want to have it mapped out that, you know, the security guard calls this person who will notify this person, or calls directly to the representative who will accompany MSHA. We also want to have multiple people trained to perform this task. So we're not relying upon one individual who might be out sick or on vacation or just preoccupied with another matter. We want to have multiple people who are trained to accompany the inspector. And I put the bottom statement in orange for a reason, because it is important. And you've probably heard an inspector say at some point in time, you can't give advance notice that I'm going to be on site. And that is absolutely true, and we want to avoid advance notice at all times. But don't let an inspector use that to keep someone from notifying the person to accompany them or management that they are on site. You know, when we notify someone that MSHA is coming on site, we want to make that a tailored phone call or, you know, text or something to that individual. We don't want to broadcast it on the CB to everyone in the quarry that MSHA is on site, so it's a scatter drill. That's obviously going to be a problem and going to cause concerns with advance notice. But, you know, in terms of this, we want to always accompany that inspector. We always want to exercise that right, because it is essential to our defense of citations moving forward. In addition to that, you know, along with accompanying the inspector, you know, we want to document what was occurring. You know, I'm sure we've all seen MSHA on site writing down the entire time. They are writing what they've seen, they're writing what they think are violations, they're writing details of conversations they had. We want to do the same thing. You know, and whether it's done contemporaneously or, you know, you go back to your office that afternoon or evening and kind of write down what happened and where it happened, especially things that maybe you think were concerning, you know, an allegation of a violation that the inspector claimed they saw you did not see, or it wasn't the way the inspector described it at that time. You know, we really want to document these so we have a record of them. If we are dealing with a situation where there's a serious investigation, you know, and we have counsel involved, or you reach out and engage counsel, you know, I will ask you to take notes for me and to label those as attorney work product. And since I'm requesting that you do that, you know, we can try and privilege and protect those notes so that MSHA can't get them later on, so that we can be honest in what we're writing in them. You know, we don't have to worry about them being used against us. But again, that only works if you have counsel engaged and that counsel requests for you to do so. And it only affects notes taken after that. So if you've already taken 30 pages of notes and then you call me up and I say, look, take notes for me, I want to see them, you know, that privilege only applies to notes taken afterwards. It isn't retro effective. So, you know, that is something we want to do. We most certainly want to have this record, and we want to keep in there, you know, if the inspector did something that concerns us, or if we don't agree with what the allegation is. Additionally, we want to take notes on or photos of what the inspector is taking photos of. Now, I always say this, but we don't want to take photos that make the situation worse, but we do want to get the photos from a different vantage point. Inspectors, I'm sure we might have seen them take a big fish photo, we'll say, where they get up real close to a hole in a guard and snap a photo. Well, when that photo's blown up on a full-size sheet of paper, it looks pretty bad. But if you take the photo a few feet back, you can see that it's 2 inches by 2 inches. So those are, the vantage points we want to look at. We also want to be, smart, though, and not take photos that maybe include another violation or include someone doing something dangerous, because then those could be used against us at a later date. But the big takeaways from this are, we want to know, what occurred on site, just as MSHA is going to have their log. Because if we don't create that record at that time, if we don't create that record while the inspection's ongoing, then we have to rely on our recollection or the recollection of others, whereas MSHA has this contemporaneous document or diary of what occurred. And that really is helpful because that's what they rely on. If I'm going to litigate something with MSHA, their Exhibit 1A is going to be the inspection notes. And they're going to rely on that so heavily, and they're going to think it's gospel. But if we can provide our own notes with contrary recollections or contrary information, it pokes holes in what they think is their gospel, their exact recollection of what occurred, and we have a different vision of it or a different view of it, and we wrote that down too. It really is something that is important. So same with if MSHA is measuring something, we want to measure it. We want to have that same measurement. If MSHA is doing health testing, we would, if we have the capability of having our own testing supplies, we should run comparing tests so that we can have our own documents or our own data that maybe is different or maybe it's the exact same, and it just tells us, look, we had an overexposure, but we want to know that. It will help us out. So we want to create that foundation for whatever we go moving forward. Maybe we look at that and say, well, we have 3 citations here, and 2 of them look like they might be valid. Well, that's something to consider as we move forward, instead of realizing that MSHA has damning statements or damning admissions from our own minors once we get 6 months into the litigation. So we want to look at that. We also want to describe in our notes or make note of what we think might be mitigating factors. So mitigating factors are those things that we think are present that reduce our negligence with regard to the violation or the alleged violation. And now that can be things, like the training or safety barricades that MSHA doesn't include in their photos or in their notes, or that this is an area that isn't traversed during normal working hours and it's got a gate on it, or there just isn't exposure because all minors are in machines, no one's on foot. Just things of that. We want to make note of that. We also want to, make note of if we are seeing an allegation that we think is just patently false. And really, there's so much going on. Everyone's very busy, especially this time of the year. We might not recall every detail of the inspection without taking this documentation or making this documentation. So that really is, one of the first things I'll ask for with a new client or with a client who has a new case is, do you have any notes on it? Do you have any photos on it? What can you get me to help us before we even get what MSHA has in their file? Help me create our own arguments and our own foundation on that. The other one is, when you work with counsel, it's important to know what your goals are going into it. And I don't mean that as you need to know that what modifications have to be made and how much penalty you want reduced or every aspect of that, but just have an idea of where your preliminary goals are. Do you think this whole citation is just a flat-out lie and you want it vacated? Then that's something good to communicate right at the beginning, because that's going to change where we go, or maybe how we address the situation. So I want to know, if you are contesting this based solely on a penalty reduction, then that's important to know as well, because maybe that determines how we go about challenging the citation. Maybe that really looks at what kind of chance we're going to get, especially say if it's the statutory minimum. We're not going to get MSHA to go below that statutory minimum unless we take it before a judge who will. So that's situations that we want to know a little bit where we're at. Do we just want it off of a fatal designation? Do we just want it as non-SNS, which is important for contractors and even for operators if you have a long history of SNS? Another thing to consider is, do we think it's issued under the wrong standard? Or do we think maybe there is a more appropriate standard? I know that MSHA loves to issue things under their 14100B, or defects affecting safety standard. And, quite frankly, that's not always appropriate, and it's a rules to live by violation or standard, so that violation is going to get more scrutiny, as well as, it could affect us in terms of our rules to live by calculator, maybe leading to more inspections. So, have an idea about where you want to go, just so we can map and kind of tailor our, strategy to that. We also want to know about any and all communication that you have with MSHA on this particular citation. It's never good to come into a citation, I begin to do the litigation, and then I find out that, you had an informal conference that I was unaware of, and that, there's a transcript where you admitted that the violation existed. That's not going to help us, and I'm not saying that's always going to happen, but, it's important to make counsel clear of all communication with MSHA on it, and then also it's important that, you don't have further one-on-one communication about the issued citations, without at least notifying counsel. And, typically we try to be the mouthpiece for the litigation, but I understand that's not always, practical, especially with abasement, but you at least want to keep everyone updated on who you're talking to with MSHA. If there is correspondence, let's do it by email so we have a record of it, or if it's by phone, let's, write down a summary of it afterwards. But we want to make sure that we are, keeping counsel aware of what has been discussed and maybe what is being discussed at that time. These might seem like pretty easy points or pretty obvious points, but, try and make one person as the point contact with the counsel, so that we have one person who is aware of the policies and procedures, who is aware of what's going on with the enforcement action we're litigating or dealing with. And I'm not saying they're the only person that will talk with counsel or will interact with counsel. I'm not saying that at all, but, having one person who maybe is the liaison, so that if, other people need to get brought in, they're the person that can make that arrangement. That's important in terms of efficiency, as well as, keeping everyone on the same page with what's going on. If we are going through an investigation, and we, might find something where we're lacking, and that might be we, found a series of workplace exams that weren't completed, or we found a series of defects listed here, or we found issues with our training. Make sure we let counsel know that. Now, we obviously can't, help you get rid of required documents. We can't help you, cover up or create new records. We're not going to do anything like that. Obviously, that's all illegal. But what we can do is we can help you maybe work towards a way of improving it immediately, and, determine what is our best action? Is that going to be to notify MSHA of it and try to work through that with them, or is it going to be, well, maybe we're just going to sit back on this and wait. We're going to do our work to correct it, and then we'll deal with what comes from MSHA if they find it. But that's a situation where it's better to let counsel know beforehand so that we can work with you on getting, some proactive steps or some proactive efforts going to correct the issue. I know that a lot of times operators are hesitant to, tell counsel, oh, well, we found this and we think we're in the wrong here, or we found this and, we know this is non-compliant, or we know we did this wrong, but, our communications are privileged, and we are, there for your interest, and so we will do everything we can within the law to help you avoid any additional enforcement there and to correct the action as quickly and as effectively as possible. It is a summer Friday, so I appreciate you guys all getting out there, and I think just like, when we were younger and wanted to get out of class a bit early, I'm going to set you free from this a bit early here. But, before you go, I just want to thank you all for joining and, really look at, some of the topics I think are important to take away. And that's, really evaluate when maybe you need to have counsel out there immediately. And don't hesitate when that time comes. Because really we do get behind the 8 ball a bit if we're, not brought into things, or if MSHA is out there interviewing people with stories critical to what happened and we don't hear any of that or find any of that out, and we're just trying to recreate it through our interviews a month or 2 months or 6 months later. So when you're dealing with serious situations, serious investigations, agent liability cases, really get counsel involved as soon as you can. It's going to make things a lot easier for you moving forward and for us to represent you and put your best case forward. Really create that foundation that we talked about. Really do think about how's the best way to document what's going on here, as well as put some of our, proactive or our beneficial information into writing so that we don't forget it later on. And then don't be afraid to talk about what you think might be weaknesses as well as strengths with your case, because, that's obviously going to be something I try to evaluate as soon as I get a citation, is where is my pitfalls as well as where is my, platforms I'm going to stand on when I'm arguing this. And, your background information, whether that has to do with training or whether that has to do with, different work conditions on the site that day, those are important. And so, be upfront about that and don't be afraid to discuss, weak points that you might find or might believe are but may not be, as well as things that are beneficial to us. So, with that, I want to thank everyone for coming. I want to, encourage you to check out the blog, MSHADefenseReport.com, as well as join us next month for our webinar. I do appreciate you jumping on the webinar today after I had to move it, so I apologize about that late notice, having to push it back from Wednesday. So thank you for adjusting your schedules. I will be sending out a recording as well as a copy of the presentation today. If there's any questions, please feel free to, type them in or reach out to me, and we can discuss any questions you might have further. All my contact information is on the page, and feel free to reach out at any time. All right, well, I don't see any questions this afternoon, so again, like I said, feel free to reach out if you have anything you want to run by me, and thanks again for attending. Hope to see you guys at the next webinar.